Picture this: you spent years building your dream game with your best friends. Development of the game was an absolute blast, but once money started rolling in, that's when things started to change. Who owns what? Who gets paid? What happens if someone wants to leave? If you don't have clear answers, you are setting yourself up for a legal nightmare. But no need to worry, I am thrilled to introduce you to Jacob Vela. He is a rare breed, as he is both a practicing lawyer who specializes in game development, and he's an indie developer who just launched his first game, Star Rift Saga. Jacob has this incredible ability to translate complex legal concepts into practical advice that actually makes sense. And in this conversation, we are covering the legal basics that every developer should know, but most ignore until it is too late. These are things like understanding what you actually own when you create your game, how to protect your game's name and brand, what makes a strong trademark versus a weak one, and how to work with publishers without accidentally giving away your IP. So let's turn that legal anxiety into confidence and protection. Welcome to Freaking Cool Indies.
All right. Hi,
All
my
right.
name is Jacob Vela. I am a lawyer, but I am also a game developer. I was a game developer first, and then I sort of used that as a launching point into law. Because while I was going to law school, I was studying the different things. Law school is very general, you don't really specialize in one thing. And I took an interest in intellectual property and contracts. And then as I'm finishing up law school, I'm like, I could use this. I could use the fact that I've been a game developer, that I've made games before to help other game developers. And that's sort of what I've been able to focus my practice on. And I've been doing this for a few years, 2, 3 years now, is focusing on independent game developers and other artists. And I recently released my first big game. That's why we've been putting off this conversation for a little while. It's called Star Rift Saga. It is on Steam. And as a lawyer, I am with Argo Law because Vela Law sounds not great because of the repeating syllable. So it's Argo Law.
Very awesome. And again, first off, congratulations, Jacob. Again, to release a game is one thing, to release a game while also finishing law school, not at the same time, but just in general, in one lifetime. It is a very great accomplishment. So huge congratulations to launching that. And obviously for our listeners, everything will be in the description below if you do want to go check out Jacob's game. It is a wonderful Metroidvania, and I've also been enjoying it on my side here.
We'll also be linking to my law firm's website, which is what I'm here to talk about, is the law side of things. And on that note, I just have to say that uh, I'm not your lawyer. If you're listening to this, I'm not your lawyer, and the contents of this program are intended as general education as a service to the community rather than legal advice. We don't have an attorney-client relationship. Your situation is unique, so if you have questions, you should seek out qualified legal counsel.
And
Yeah,
hopefully that qualified legal
I
counsel
have to
is you.
say that.
Absolutely. No, absolutely. And again, just to kind of put a nice bow on that, for the sake of this conversation, we are going to be talking, let's say, US specific, for anyone who is listening globally. However, and Jacob, please keep me honest here, a lot of what happens in the US is also typically recognized, but once again, back to the disclaimer, this is something that you should also be seeking out if you are moving forward with any of the things that we are discussing today.
Yeah, we'll be talking about intellectual property and contracts, which for the most part, the United States has largely exported their intellectual property laws. It's pretty similar throughout the world conceptually, but you should seek local counsel with specific situations. At the US, though, it is a federal thing. It is state states don't have as much to do with it for the most part for most of what we'll be talking about. It's nationwide.
So, with that, I think that is a perfect springboard to something that you have actually mentioned a few times so far: intellectual property. So, most people know it as IP. You know, they hear, oh, Microsoft's got some great IPs with Halo and Forza, and typically something around that vernacular. But Jacob, what exactly is intellectual property? What is IP? Sorry, not IT. What is IP, and why do you think that it is game developers' most valuable asset?
Yeah, to that, I think it was Microsoft actually in some conference that said that new IP is the lifeblood of the industry. It might have been a different company. And so they consider it very important. So intellectual property refers to creations of the mind. This would be in contrast to something like to other things that you can own. So real property is land and buildings, or physical property is stuff that you own. Intellectual property is creations of the mind. That usually takes the form of patents, copyright, and trademark. Those are kind of the three main bodies of intellectual property. And the law gives those creations some degree of protection, like it would for stuff or land or buildings. The law protects that you own those things. Intellectual property is giving protection to those creations that you have made through your creative endeavors. It's valuable because video games are made entirely up of intellectual property. If you think about any studio of any size, whether that's indie, AAA, if the tiniest indie company of one person all the way up to like Nintendo, their value is not in their assets. It's not in their physical goods. It's not in their land. It's not in their real estate. It's often not even in their employees or their structure. It's in their intellectual property. Their entire value is IP. Um, and the IP system, it's gotten a lot of criticism, especially since I mentioned, big companies and how they use it. Nintendo comes to mind there. It's gotten a lot of criticism, and there is room for the IP system and IP law to improve. Don't get me wrong, but I still think it's very important to understand what the law is and how it can protect or potentially hurt you as an independent developer. So, IP, it's creations.
Gotcha. And is those creations, is that something that is automatically created, or do you have to file for an IP? I've like you've created a game, are you filing saying I am the one who has created this particular game?
We'll probably get into it more when we talk about each of the kinds of intellectual property, but it depends on what kind of IP we're talking about. For copyright, for example, you get some form of protection through common law simply by creating something. But as soon as you try to enforce those rights, say through litigation or issuing a cease and desist or, a demand letter, you would want to file. You'd have to file as a step of that process. So for most things, I would recommend filing and formally registering, but you get some degree of protection just by creating it. For patent, you pretty much have to get a patent, but patent's really not actually very significant for indie developers. And sometimes trade secrets are thrown in there as a type of intellectual property. We're probably not going to talk about them. It's just things you want to keep secret. You usually don't register those because that would be disclosing them and somewhat would defeat the purpose. They're mostly protection, or they're mostly creations of contract rather than intellectual property as we usually think of it. They're sort of this weird fourth branch, if you will.
This is totally unrelated to games, but would something like the KFC secret recipe, is that a is that would that fall under the secret side of things?
Yeah, phenomenal example. Recipes typically can be patents, but patents, we're getting a little off base, but I will
Yeah,
say
yeah,
this
yeah.
is the distinction here.
Yep.
Patents, usually a recipe would be a patent, but patents only last for a certain number of years until they just become part of the public domain. By keeping the secret recipe for KFC or for Coca-Cola a trade secret instead, they get a little bit less protection, but as long as they keep it a secret, it stays a secret.
Gotcha. Very cool. All right. Wicked. So going kind of veering that ship back to games and off of delicious fried chicken, can you give us a brief overview of some of the main types of IPs? And once again, I know you've talked like patents, copywriting, trademark. I'm guessing those are some there, but can you kind of dig in and differentiate a little bit of those?
Yeah, let's talk about them from the top. So the most important for a game developer is copyright. Copyrights, everything in your game is protected by copyright. Uh, it protects art, code, sound, music, your story, even characters can be protected by copyright. It protects everything about the game. The game as a whole is protected by copyright. It doesn't necessarily grant you the right to do anything with your work. This is the case for most of what we'll be talking about, but rather it gives you the right to exclude others from using your work. So I created a game. I have a copyright in that game. That doesn't give me the right to make copies per se, but it gives me the right to exclude you from distributing my game or pirating it or making a sequel to my game or doing any number of other things using my intellectual property. Trademark is different, and they're often confused among people who kind of don't have a formal any kind of legal knowledge. But copyright and trademark are very different. Trademark is it protects your brand. It protects your name, essentially. Your name, your logos, anything else that identifies the source of your goods or services. So if we're talking about video games, those primary areas would be your game's name and logo, as well as your studio's name and logo. Patents are very rare in game development, and we're probably not going to want to talk about them a ton. But just so that you're aware of what
Mhm.
they are, it protects inventions. Patents are kind of the big one that people hear about among them. Uh, they protect inventions are pretty rare among indie developers, and they're really expensive to get, and they're usually not worth the effort. And usually, what you think is patentable probably isn't actually patentable.
Yeah.
Usually in video games, they would cover hardware, so consoles, controllers, things like that. But there are certain kinds of patents that have applied to video game concepts, like the little wheel in Mass Effect that you use to select your dialogue option. That is protected by patent.
No
The
way.
Nemesis system is a pretty famous one from
Yep.
Middle Earth, Shadow of War,
Mm,
Shadow of Mordor. Those
yep.
Middle Earth games.
Yeah.
Those are that is a patented system. And yeah, it stops other people from using your patent, your creation. But again,
Yeah.
for an indie developer, really rare to get a patent. Generally, if somebody came to me and said, "Hey, I'd like to get a patent," I'd say you probably don't. And in fact, if you wanted to get a patent, you would actually have to seek out a specialized lawyer who takes a totally separate bar. It's a very specific field of law.
Very interesting. Yeah, and I know the Nemesis system for me is, I think, the only case of patent of like of a video game concept or mechanic, if you will, that I was familiar with. I know that Warner Brothers managed to lock up and now has totally stopped everyone else from implementing that wicked ass mechanic into their games.
Yeah.
So,
And there's also cases where people have patented stuff with the explicit intent of making it available. They'll patent it so that nobody else can monopolize it. I want to say off the top of my head, it was Apex Legends who patented the ping system that they use in that game.
mm,
And then, because you can make a ping, it's a little bit different from how it is in other games. You can make a ping and it puts a projection out into the world. And so they patented that with the intent of, hey, this really improved game accessibility. Let's put it out there so people can use it. So patents can
cool.
be wielded for good too.
Good.
I'm gonna
Good, good,
fact
good.
check myself on that one. Make sure that's the one I'm thinking of.
We'll put a little disclaimer at the bottom of the screen if we are thumbs up or thumbs down on that one there. Uh, awesome. And then, Jacob, I guess, what are some of the bigger misconceptions that developers have with, I guess, like what they own or from what they create?
I think a few of the big ones that I've heard is, first of all, there's what's called the idea expression dichotomy. So that is to say that your idea is usually not protectable on its own, but the expression of that idea is protectable. And that's typically used in copyright. It's a copyright concept. That is to say, the idea of platforming is not protectable, but the specific expression of Super Mario Brothers that is protectable. And it can get into the weeds a little bit. I think something that's very, very poorly understood in general is fair use, and I feel like we could probably do an entire episode on that. But the big one I've seen a lot from people who are not talking to lawyers is with fan games because they think, oh, well, I'm making it free, so that makes it fair use. That is not the case. And if you're arguing fair use, you're usually not in a great spot anyway. And then there's one that I heard recently. It was the 30% rule, and I've also heard it as the 10 things rule. And apparently, this was taught in an art school. And that is to say, if you change either 30% of a thing or you change 10 things about the original work, then it's fine. You're no longer infringing. And that's not the case. There's no doctrine behind that.
And question for the fan made one or the fair use one, is that due to the trademark side of it? And like how you're saying how it's the brand is trademarking, and by people creating these things, like let's say Nintendo, if someone makes a fake Super Mario, it is because they don't have control over how that game is portraying from the brand.
Well, it would be if you were making a Mario fan game, it would probably be an infringement both of trademark because the Super Mario brand is protected by trademark, but it would also be an infringement of copyright most likely. And yeah, they could tell you knock it off, take it down because Mario as a character is protected by copyright. There was a case involving the Batmobile of all things. The Batmobile was considered to have protection as a character. If there are certain defining characteristics, a character is protected by trademark. And what people always try to argue is, well, it's parody. Well, it's fair use because it's free. And fair use is a fairly complicated concept. It is a legal defense you would raise in court when you've already, it's infringement, but fair use. And usually you just don't want to be in a position of having to argue that. But again, that could be its own topic. It's fairly involved.
Yeah. Okay. Very cool. And then I guess lastly, why is it important to have, I guess, clear ownership of your IP, and especially when you're going into talking with, publishers, investors, people who are going to be putting money towards the thing that you are building.
Yeah, I think it's important even before talking to a publisher or investor, because you don't want to deal with a tangled web of intellectual property where something's owned by one person or somebody may have a claim against you in the future. And a publisher or investor definitely doesn't want to deal with it. Ideally, when you're setting these kinds of things up, you want to set it up so that your studio as a legal entity owns the IP, that the studio is this convenient bucket to put all of the intellectual property rights in whatever you're making in your game, that the studio can own it. And that gives you a lot of flexibility as far as, hey, everything's here. We can sell the studio, we can sell the game if we need to. You don't want a case where you're working off of somebody else's IP and the rights they may claim against you later, or somebody may have some claim. It's just easier to keep it, avoid that tangled web of things. You want rights in what you're building your business around.
Okay, perfect. And lastly, before we dive in, because I do want to kind of piece apart and pick apart, copywriting and trademarks and kind of dig a little bit deeper. But when is a good time to start all of this? If I am just opening up Unity for the first time, I have maybe some idea of what my game semblance is going to be. Is that when I want to start thinking about this legal side, or am I waiting until I have something that is like, all right, this is moving forward to a launch, whether it's 3 months, 6 months, 9 months from now?
Well, first of all, if you're opening up Unity for the first time, my personal take on this, and this is a little bit less lawyer, a little bit more game developer, is you shouldn't be thinking about making a commercial product for quite a while. Take the time to learn the craft, build the skills, get to the point where you can actually make something like that. Spend some time, have fun, just make stuff. Don't worry about that yet. But on the legal side of things, it depends on what kind of intellectual property we're talking about. Trademark, you can do before your game releases, or you can also do it after, but not too far before. And because there's a limit to how early in advance you can do it, because you have to be using it in order to get a trademark registered. And copyright, you can do as soon as your game releases, you can do it. You can register a copyright. It does cost money to do both of those things. So if you're just opening Unity for the first time, you're still early, cool. Probably don't worry about it yet. But as soon as it is reasonable to do so, is what I would say would be the general answer. And for copyright in particular, as soon as you fix something, because copyright protects creative works that are fixed in a tangible medium of expression, is the whole legal definition of it. So as you're creating something, it's not quite fixed yet, but the individual assets, that model you made, that sprite you created, those become fixed, and you do have protection over individual assets just by creating them. So don't worry too much about having to register everything. You get some degree of protection as soon as you make something.
Okay, perfect. Yeah, that actually segues perfectly into my next question, which I know, again, we did speak about a little bit before, but for the, is it automatically generated or do you apply? Like if I draw a character, if I create an asset, that from what I am taking so far, if I have this correctly, I create a net new asset out of thin air. I do not need to apply to anything. That is just simply belonging to me at this point.
Yeah, you have certain rights in it from the beginning. For more protection, you should generally consider registering. And I would say you probably don't need to register every single asset, but you
Yeah.
should register your game as a whole. That just makes more sense. Copyright registration is really cheap. It's really easy to do. Like, seriously, it's something that I would feel comfortable with most clients just saying, yeah, can I just do that myself? I'd be like, go ahead. It's pretty easy. It's pretty hard to mess up. That's not going to be the case for trademark, but for copyright, it's pretty easy. And when you want to enforce your rights against somebody, you pretty much have to have it registered at that point. If you want to take something down, if you want to go to court, registration is a requirement. And by being registered, you've effectively put the world on notice saying, hey, world, I made this, I own it. Don't steal this.
Hey, I hope you're enjoying the conversation, but I wanted to take a quick second just to tell you about today's sponsor, me. Well, actually, more specifically, the 7-day marketing foundations challenge that I have put together. So, if you've gotten this far in the podcast, then I know that you are serious about becoming an indiepreneur and building a strong marketing foundation around your game. So, I have a challenge for you. Give me 20 minutes a day for the next 7 days, and I will give you a marketing system that actually works. Each day builds upon the last, and throughout the 7 days, we're going to be doing things like defining your ideal player, crafting a killer pitch, optimizing your Steam page, and building an outreach list, as well as sending some emails with some proven and provided templates. Look, there's no overwhelm, just small daily wins that will compound into real results. So if you want to learn more, check out the link below in the description, and I cannot wait to cheer you on. Besides that, have a great rest of your day, and let's get back to the episode. And if you register your game, that encapsulates, again, all of your assets, all of your arts, all of your story. That will just
Yeah.
encapsulate everything into that bubble, right?
Everything that is protectable, you'd pretty much be good to go.
Perfect. Beautiful. And then I guess, what is the fundamental difference between a game idea and the expression of that idea?
You know, it's kind of a broad question. It's kind of hard to define because it feels very abstract sometimes. But an idea is, hey, I want to make a platformer where you do these things. And an expression is the actual game. So certain ideas are not protectable by law. Expression is protectable by law. So I don't know, let's pull an indie game, Shovel Knight. The idea of a knight who uses a shovel, that's not protectable. But Shovel Knight the game, the actual expression of that idea, that is protectable. And where it can get a little funky is sometimes some ideas could arguably be protectable because they're so, it gets weird. Look, like the concept of a lightsaber feels like just an idea, but there's a very specific expression of a lightsaber to where a lightsaber could be considered protectable in some contexts, but an energy sword from Halo is different from that.
A lightsaber is just a glowing sword if you kind of deduce it down, and like, is a sword something that people can kind of.
Yeah, and in general, the answer is no, but specifically a lightsaber can be in some contexts. So, what I'm getting at is to simplify the idea expression dichotomy because there's a lot of reading you could do about it. There's a lot of stuff that'll come up that's very specific to a specific set of facts. An idea is not protectable, the expression of the idea is protectable. And where we get a little bit weird is some people have tried to argue there's a case. It's called, I want to say Tetris Company. It's Tetris v. Mino, is how I explain it. Where Tetris, the Tetris company, the rights holders there, was suing the creators of another game called Mino. And they basically just made a mobile version of Tetris, with the only difference being the colors looked a little different. And they tried to argue, well, the idea of falling blocks and matching lines is not protectable. Well, the expression of those ideas was so close to Tetris that it kind of is protectable. You cannot just change a few things, change the colors, change a little bit to get protection over it, to make it a different idea, or in a different expression, I should say. Same idea, different expression.
Yeah. Okay. And again, I definitely understand how easily this can all get tangled, and because again, you go back to even something like a mechanic, right? There's a
Mm-hmm.
lot of games that hold the same mechanic. Any game that ends in simulator, for example, has a very similar mechanic, or any game
Yeah.
that's a Metroidvania has a similar mechanic. And I'm guessing that is something that cannot be like, I own this.
That's actually a really great distinction. I like that a lot. A mechanic in, I'm going to say almost every case, just to cover my bases, because I'm sure I'll think of one later that's like, okay, no, that one's probably okay. In general, pretty much every single mechanic you can think of, that is an idea. That's the expression of that idea is protectable, but the mechanic itself is not. In Dark Souls, you die and you drop your souls. In Shovel Knight, you die and you drop your money. In my own game, you die and you drop some stuff. Yep, that's an idea. That's not the specific expression of how that's done, the way souls are presented, the way the whole totality of the thing. That is protectable to a certain extent.
Okay, I think that I got you. I'm following along. I'm with you. I'm
Yeah,
basically,
mechanics are generally ideas. They're not expression of ideas. How a mechanic is implemented, that's an expression
yeah, and then that becomes what is like, no, you cannot do this way because it
because
is
it's part
different
of
from
the
game to
game
game.
as a whole. I would say the
Gotcha.
specific way a mechanic is implemented, like in isolation, usually probably not protectable because it's still just an idea, it's still just a concept.
And at the end of the day, it's like, is a company going to go through the lengths of the legal system for like something that is once again also replicated thousands of times against a different thing there. Okay,
Yeah, and at
perfect.
that point, we're going to get into totally different doctrines, but I think that's a pretty good explanation for where we're at.
Yeah, I'm with you. All right, so let's shift off of copyright and jump into. Is it fair to say it's Big Brother trademark? Is that like a?
Ooh, it's equal, brother.
All right, cool.
It depends on
It's
what if for game developers, I think copyright's the bigger one. If you're running a business that's not a game development studio or other creative work, I would say trademarks probably the one that every business should think about at some point.
So let's jump back into trademark. So once again, I know you have touched upon it, but with just the complexity of the legal system, can we go over one more time of like how is a trademark different from copyright, and then what is parts of the game that it does protect? And I know again you said brand and things along those lines, but let's just reiterate before we kind of dive into this section.
Yeah, so trademark protects your brand. It protects who you are. It stops me from releasing a podcast called Freaking Cool Indies because you would presumably have the trademark in that in our hypothetical and people being confused. Wait, which freaking cool indies is this? Is this Mike's freaking cool indies, which is the good one, or is this Jacob's crappy freaking cool indies that's not as good? So then people start to associate that brand and it's like, "Oh, they start to have positive experiences with your freaking cool indies and I'm kind of mooching off your goodwill after a while." So that's kind of a high level overview of why trademark. But trademark protects your brand. For game developers, this usually concerns two big things is your game's name and your studio's name. And with both of those, it's also the logos. But for most studios and most games, I would say do the name. That usually covers better protection rather than the logo. Um, and if you have to, yeah, so it protects your game's name and your studio's name. That's the big thing. It's part of your brand that acts as the identification of source. In other words, who is making the good or service? Who am I getting this from? um you do have to use a trademark in commerce in order to get any kind of protection over it, so you have to actually be using it. And just announcing your game is not enough to be considered using it in commerce. You have to actually be selling the game. That is enough to be considered use in commerce. And unlike copyright, they also last forever. Copyright lasts a certain number of years. You probably heard about Mickey Mouse entering the public domain because Steamboat Willie had been out for a certain number of years. Trademarks can last forever as long as you're still using them. So there are certain trademarks that protect Mickey Mouse. Yeah, Disney's going to go ahead and keep those trademarks forever as long as they're still using them. It does also mean with that, you do have to enforce them. So that's a little bit different from copyright, where if I see you infringing on my copyright, I can just say, yeah, that's fine. I'm not too worried about it. But a trademark, I kind of have to enforce it. Otherwise, I risk losing it.
Oh, okay. So if you do not enforce it, then by the system's eyes, it's saying, okay, well, it's like you've trademarked this, but there's clearly other people using it. But if you're not going to use it, then we'll just open it up back to public domain.
Yeah, kinda. If you see 20 people using your brand and you don't do anything about it, when the 21st person shows up and starts using your brand or your name or your logo or whatever we're talking about, then they can say, "Well, you didn't stop those guys and you clearly knew about them. What's
Yeah,
the deal?" And it weakens your protection. There is
gotcha.
also a danger of something called genericide, which is kind of related but not quite, where something becomes the generic name of something. It can actually get your trademark canceled. We'll probably talk about more about that later, I think.
Yeah, awesome. And then last question, because I know on Steam there are games that are named the same, right? I think for example, one game that we've actually talked about quite a bit on freaking cool is called Lucid. And I know in just searching Lucid from before, there that name exists across a handful of games. Now, I'm one thing that comes to mind is the Lucid that I'm referring to is all capitalized letters, so maybe that is counts as enough of the differentiation.
It's
But
not.
otherwise, okay, so otherwise, is it the combination of like title as well as, let's call it, capsule art, or is it just the fact that maybe none of the people who named it Lucid have trademarked Lucid?
I can't comment on the specifics of the situation because I don't know why or how those games share the same name. I don't have the necessary facts here, but
Hmm.
oftentimes what'll happen is they're simply either unaware of each other or don't realize that they could be stopping each other. But if
Gotcha.
one of them went and got the trademark, there's a possibility that they could say, "Hey, I did get the trademark. You didn't stop me from registering this trademark. Sorry, I get the name now."
Yeah,
So
yeah,
you
okay.
may see things concurrently named, like named the same thing in the same space, and that's usually just because they just haven't stopped each other. They don't know they
Yeah,
can, or they don't know that they should.
okay, wicked.
But I don't know the
And
facts of Lucid specifically.
yeah, no, 1,000%. And again, I definitely appreciate once again the disclaimer on that one. I
Yeah,
was just more so
there's
trying
what
to
the
figure
law
out because
is, and then there's how it works in practice. And sometimes they're two very different things.
yeah, 100%. And Jacob, what makes a strong trademark that's easy to defend versus a weak one?
So when we talk about easy to defend, I'm going to kind of change your question a little bit. And we're going to talk about easy to register because that's generally the first step in defending a trademark. And anything that would make it easy to register but harder to defend, we're kind of into the fact specific situations. But in general, I would say if you can register it, you're going to get better protection. So that's the key thing. So when you're looking at a trademark and you want a strong trademark that'll be easy to defend as well as easy to register, you're going to look at something called the Abercrombie spectrum of distinctiveness. And this is called that because of some case involving Abercrombie and Finch, the clothing company. And it's basically it's a spectrum. So there's 5 levels to it, but they're not like distinct levels like a staircase. It's more like a slope, where on the one end you have things that are fairly generic and they are not protectable at all, and on the other end you have things that are fanciful and arbitrary and they're very protectable. So going through it, we have things that are generic. They're like no protection and can't be registered. This would be calling your video game or platformer. That's not protectable. That's generic. You can't, it gets no protection. It can't be registered. Descriptive would be something that describes the goods or services, and they're protectable only when they acquire secondary meaning. That is to say, you can show that the general public associates this name with your specific brand, and that's kind of hard to do. Like that's difficult. It's expensive too.
Oh, I was gonna say, sorry to cut you off first off, but I'm guessing
Sure.
that's something like Kleenex, right? Where it is like Kleenex is the brand, Kleenex, but people typically refer to Kleenex when asking for a tissue.
So I'm going to answer that at the end because Kleenex, if we're referring to that, that would be an example of genericide, which I alluded to earlier.
Oh,
But
perfect.
no, I'll
Okay.
talk about it now. So Kleenex is the brand name, and that is a very strong name on its own. But it would be at the very end of the spectrum where it's a fanciful or arbitrary name. I'd say it's arbitrary.
Hmm.
And it's just been used as if it's used too much as a generic name, you would see it become more generic. It becomes more descriptive or more generic to the point where people associate this with paper tissues in general rather than one specific brand. Back in the
Gotcha.
90s, Nintendo ran an ad campaign where they put out ads basically saying there's no such thing as a Nintendo to stop all the mothers and grandmothers from referring to a Sega Genesis as a Nintendo because that risks genericide and video game companies' values in their intellectual property. So they didn't want it to become generic and become a Nintendo. No, Nintendo's the company. They make the Super Nintendo console. They were very
Yeah,
specific about that. We could probably link to, I can probably find the advertisement and you can link to it in the show notes.
absolutely.
Anyway, a descriptive good is something that describes the product. So it would reflect the content, quality, characteristic, or function of a good or service. So an example I like for this one, it comes from Parks and Recreation. Ron Swanson started his company, the Very Good Building and Development Company. That's a descriptive name. He would say it's simple and to the point. It's accurate. And I would say that's a terrible trademark. It's descriptive. You're never going to get it registered. He probably wouldn't care. The video game example would be calling my studio the Very Good Game Studio. After that, you have suggestive. This is where the name suggests something about the good or service. And now we're into the territory where this is registrable, this is protectable, but you want
Okay.
to ideally be even more distinctive. And these would be hinting at the nature of the good or service by the name, but it usually requires some kind of leap of the imagination to get to what they actually do. So, some examples here would be, I pulled up an example, it would be electronic arts. Well,
Hmm.
they're electronic artists, or arguably Street Fighter. It suggests at what you do in the game. Then we get into arbitrary things, which are things that are even more protectable. This is great. This is where we want to be. Arbitrary is some word that's generally not associated with what you're doing, but it's a real word, but it's in unrelated context. Pretty much always protectable because it's very distinct. This would be things like Valve or Bungie. These are real words, but they're not usually associated with a video game company. It doesn't immediately come to mind. Finally, this is the best protection. This is where you want to be. These are fanciful things. This is where you made up a word with no inherent meaning. And arguably, Pokemon. That's a made up word. That's a shortened version of Pocket Monster. Pokemon is distinct, it's fanciful. Sega comes from the words service games, very protectable, fanciful. So if you want a strong trademark, you want to be as distinctive as possible. You want to be suggestive, or even better, arbitrary or fanciful. Make up a word if you can. I've worked with clients on trying to register their trademarks. Coming up with a good name is hard. You'll notice that as we get into fanciful, as we get into more distinctive names, it gets harder to figure out what you do. If you didn't tell me what an indiepreneur is that had no context, I probably wouldn't know. A
Yeah.
company like Valve, what does Valve do? Oh, they must
Yeah.
make hardware like pipes and stuff.
A
Well,
1000% plumbing company.
which is why trademark is so significant, because it gives protection to the fact that you've built up this brand, that we know what Valve does and they've built that up. So we protect that. We want them to work to build that. I said at the top of the episode that intellectual property protects creations of the mind. Your brand is a creation of the mind that you've put labor into.
What are some of the basic steps that they can take to just see, what is available, what is not? Is this trademarkable? Is it not? Is it as easy as a Google search?
That would be the first step, is to do a Google search. I would say do a Google search, search storefront, search not just if you're publishing on Steam, don't just search on Steam, search the App Store, search the eShop, search Microsoft Store, search all the stores, see if there's something similar. The standard that Trademark looks for is not the exact same name. When you're forming a company, it's the exact same name. Another company can't have the same name as you. When you're searching for trademark, it's something that would be confusingly similar or would have a risk of confusion to potential customers. So if we were talking about Lucid earlier, Lucid would probably look up the other Lucid and be like, okay, yeah, that's arguably confusingly similar. So let me change it to Lucids. Nope, that's still pretty similar. So that would be the first step. Search the internet, search these kinds of things. Second, I would say if you really want to be sure of things, search the USPTO, that is to say, the US Patent and Trademark Office. You can search their website. You can search what marks they have registered. Just keep in mind that every single week, thousands more come out. So things might change by the time you hit release. And any lawyer who is helping you register a trademark, because I said copyright, if a client said, can I do that myself? I'd be like, yeah, probably. It's pretty straightforward. Trademark, I would not say that. Trademark, I would say, I'm going to have to do a search. I'm going to have to compare your mark against a bunch of others. We're also going to have to talk about the Abercrombie spectrum. And it sounds straightforward with those whole 5 categories. It sometimes it isn't. It's hard. And it's not just your opinion that will matter, it's the examiner's opinion that will matter. So you want to play it safe if you can. It takes time. You should do a search, but if you were applying for a trademark application, I would do a search first with the USPTO web database, and I would look for something that would be confusingly similar. It's a process, but just starting and doing that quick search on your own really helps you get a sense of what's out there, what's obvious, and oh yeah, I should have thought, obvious name that's so common. Yeah, of course it's taken already. But just take the time and do it. Don't fall in love with your idea too early.
And I guess before jumping to the next section, anything else that we haven't touched upon for either copyright, for trademarking, anything else that you think would be valuable for our listeners to know about these two types of IP?
I think in general, I haven't mentioned this yet, but if you're using somebody else's work, whether that's copyright or trademark, you need a license. That's the default rule is you need a license. So when something's protected, you're able to say to other people, "Hey, don't use my stuff." The same goes both ways. If you're trying to use something that's somebody else's, don't. So make sure you get a license to whatever you're working with.
Perfect. And that would be, again, the easiest example. You go on the Unity store to buy, or the asset store to buy something, and now you have the license to use whatever that is that you've purchased.
Yeah, and if you're working with an asset store, make sure it's a reputable one. That is to say, there's not just people uploading assets that they got from somewhere else and stole onto that asset store, and make sure that the asset store's terms allows you to do what you think it lets you do with the asset. So if
Mhm.
you're trying to do it for commercial use, make sure you can actually use your assets for that.
Yeah.
And when in doubt, talk to a lawyer.
Let's say I did use a non-reputable source without, I had no idea. This is not something I went out to look for, but I did not know that they had stolen the asset. At the end of the day, I would still be liable, maybe not from a financial situation, but like I would might have to pull that asset out of the game if something were to have happened to that storefront.
Yeah, if the rights holder asks you to, having to pull it out of your game would be the minimum you would have to do. Uh,
Okay,
you could also have to pay for damages, but now we're into the specifics of the situation.
of
You
course.
could have to pay what's called statutory fees, which means, hey, that was registered. That was they're entitled to a minimum number of fees from you for infringement.
Mhm.
So careful.
All right, so speaking of being careful, it is time to jump over to contracts, which is ideally, and again, let me know if I have this correctly, but this is the way that we are securing these IPs is through kind of contract and making sure that, everything is agreed upon.
Yeah, for our purposes, when we're talking about intellectual property, that is what we are trying to do with a contract. So, a contract is just an agreement between two or more parties that has mutual obligations. I'm going to do this, so you're going to do that. And in law school, they'll teach you all about how it involves an offer, it has acceptance, and then there's consideration involved. Two people agree to do something in exchange for something else is the basics of what it is. And we usually think of a contract as that written piece of paper that we both sign at the bottom. That is a written contract. It's basically a written form of our agreement. So contracts can be verbal and can be written, but written is pretty much always preferred in a business setting, especially when intellectual property is involved and it's even required to do certain things with it.
Mhm.
Uh, the time to you asked earlier about the time to do copyright registration or trademark registration. Those can be done close to or after your game's release. Contracts you should do as soon as you start doing anything with anyone else. It's time to get a contract.
Okay, and that includes, like you and a couple buddies, you're sitting around the room and you're saying, "Hey, I think we should put our minds together and make a game," right? Is the next step ideally, and this is probably not happening as regularly as a lawyer would love to see it, but I'm guessing the next ideal step would be one of them takes the initiative to set up, okay, let's grab a contract, let's make sure, everything is kind of crossed up.
Yeah, that would be the ideal. But again, like we said, the law works a certain way in theory and in practice, it can be different. I would say to those people, you should probably also be forming a company like an LLC or something to hold those rights. But the big issue they're going to run into as far as intellectual property goes is when this group of friends makes a game together without any kind of formal agreement, who owns the intellectual property by default? The answer is all of them. All of them
Mhm.
own it.
Okay.
So it can get very messy very quickly. But the default under copyright is that copyright is owned by its author. When you have multiple authors all working together on a work that comes together and forms one thing that's sort of this big collaborative whole rather than a bunch of individual pieces, then it's owned by all of them as what's called a joint work. So a joint work is owned by everyone equally, regardless of how much they actually contributed. And every author also has an interest in the entire work, not just what they did. So any of them could sell it then, and they'd have to account to the other co-authors for any profits earned from the game because they all own it equally. It's and there's some argument to be made that some parts, like the soundtrack, could be owned by one individual, but again, we're into the fact specific situations here, and the video game is what we're talking about. It is owned by all of them, and it's really messy. And if you're making a commercial product, that's not something you want to deal with. So This is something you want to take care of. So what you do is you get a contract that kind of overwrites that default. It assigns the interests in the intellectual property to a singular entity, ideally, if you're doing it in the right way. Either one person or one company owns the entire work. So for my own game, I worked with independent contractors to do art and sound. And the work done on that was a work made for hire that my company, Studio Vela, owns.
Mhm.
So a contract acts as a way of getting around that default rule of the author owns it. And there's more to it. Like if you're working for a company for like employment, if I'm working for Nintendo, yeah, everything I do in the scope of my employment, that's going to be a work made for hire. But an independent contractor agreement can kind of help you get around the default rule without having to have a full-time employee.
Doing something like setting up an LLP, again, let's say four friends around the room, they're setting it up. Is that something that's fully custom, or is something that's like, a template off the shelf? Is that something that they might be able to utilize?
So again, we're getting into the it would depend on your situation sort of questions. But for a single member LLC where it's owned entirely by one person, I would say that the off the shelf template contracts do a pretty good job for
Mhm.
99% of situations. For multiple members, they don't do quite as well because there is a little bit more custom you have to do as far as voting rights, who owns what, and that you should work with a local lawyer. That everything I've talked about with intellectual property is mostly federal law. That you would need a lawyer specifically in your state to do, depending on where you're incorporating.
Okay. And a little off topic, but I guess the same. Obviously, you are a video game lawyer, if you will. Like that's your specialty. But if you go to a mom and pop lawyer down the street, does them not having the context of a video game, does that hurt or harm, or is there any real difference? Or again, at this point, lawyers can kind of navigate through most of these
Yeah.
things.
What you'd be looking for in that situation is a business lawyer. And I would say the knowledge of video game specific stuff is not nearly as important in this context. As far as they're concerned, you're setting up a video game studio, it's a business. That's really all they need to understand. They don't need to understand the nuances of publishing agreements and stuff like that. I think that the single most important purpose of a contract, no matter what the contract is its clarity and predictability. It's that lays out the terms of your agreement. I think a lot of people have a fear of contracts like, oh, I don't need a contract with my friend. I trust them. Well,
Mhm.
yeah, that's great. But the purpose of a contract is that you and your friend can agree on something and have it laid out, have the rules of what your agreement is laid out in clear terms so that you understand what's being agreed to. All too often, people will agree to something, be like, well, I didn't think about this specific thing, or oh, I thought we were agreeing to something else. And that's how deals fall apart. That's how groups of friends working together on a game fall apart. And if you're working on a game jam game together, I wouldn't be too worried about for writing a written contract or anything. That's great. You're making a game jam project, you're doing it over 48 hours or 2 weeks or whatever the game jam term is. Great. Don't worry about it. Go make a game. You don't have time. But as soon as money starts coming in, that's when the disagreements start. That's when you start to run into these problems. That's when it's like, hey, I have an interest in this intellectual property here. Hey, I contributed this or that. If it's a commercial product, you definitely need a contract at that point. But the purpose is not because you don't trust somebody. The purpose is to clarify so that we understand what's being agreed to.
All right, Jacob. So I know you spoke about it with your own studio, talking about independent contract agreements. But what are some of the clauses that you would say must be added to this document to protect the developer? And I'm guessing some of it is also to protect the person that you're hiring, whether it's artist, sound, engineering, whatever that ends up being.
Yeah, it would depend on what the situation is, the specifics of the situation, as well as who I'm representing, what I would be looking for in the contract. But probably the most important thing for our purposes of what we've been talking about is making sure those IP ownership issues are taken care of, making sure that you know who owns the finished work and how that's being handled. Is it just the studio owns it, or is it being licensed to them? If it's being licensed, under what kind of term? Because sometimes the studio doesn't own it. Soundtracks in particular are a popular example of that one. Soundtracks and sound effects. Um, you would also want to define very clearly the scope of work. That is to say, what is actually going to be done here and what are the terms upon which it will be done. Make sure it doesn't balloon out of control. You don't need to have all the very specific details of that, especially
Okay.
because early on in a project, you're going to have one idea of what it's going to be, and it's going to be like, actually, we should include another boss here. That
Hmm.
happens. You don't have to have
Hmm.
all the details, but general terms, what it is, that's important. You also want to make sure you have payment figured out. That's probably one of the other really important ones, which would be like clear definitions on how much is being paid, when, how it's actually earned, is there a royalty, those sorts of things. I think there are certain warranties and indemnifications that are important to have, but those are like the granular things that are, hey, I promise to do something, or I promise that something is true, and if it's not, this is what happens. And termination. How does the contract end? I think that's an important one to be thinking about. And that's goes beyond just independent contractor agreements, but most contracts you don't want them to be forever.
Yeah, I never really thought of the how this ends, but I guess that does make sense. And just to kind of reiterate and make sure that I'm also understanding it, within a contract, it doesn't need to say, all right, if I hire you to help make the soundtrack for my game, it's not going to say Jacob must provide me 18 songs that are 2.5 minutes long, but rather it would be something along the lines of, upon completion of this contract, like Michael is the sole owner of the music that Jacob has created.
That's not how I would write it, but you have the
Yeah.
general idea.
Yeah.
There's a certain way that I like to write that, and you would write it as a work made for hire, which requires a certain way of writing it. Uh, but yeah, no, you don't have to say it will be 18 songs and it'll all be 2.5 minutes. If anything, I find that stifling for the artist. It should be, I think it, I think in general, it could be as basic as we'll write the soundtrack for the game. And honestly, that I think as long as the parties understand what's going on, that's the level of detail you need. And I would go so far as to say, when you're working with your artist on that, hey, talk to them. Just be communicating, be saying, hey, I'm thinking this area could use a different song. If they're like, actually, I haven't budgeted for that much time, okay, cool. You just got to make sure you're communicating that as the project develops.
Awesome. Well, Jacob, this has been amazing. First off, I've thoroughly enjoyed this conversation. But before I let you out of here, there's a few things. And number one is, one thing I do with all of my guests is I want them to continue paying it forward with us amazing indie developers and indie games. And there's just so many amazing people out there. So, Jacob, I want to give you some time to kind of give a shout out from the rooftop of an indie developer, an indie studio, an indie game that you've just been really enjoying that you would love for the audience to check out.
Well, I'm gonna cheat and say my own game, Star Rift Saga, but that's not fair. That's not paying it forward. But I released it. I'm happy. I'm proud with it. But aside from that, there's a game I've been playing called Maze Mice. It is by Dan DeLorio, who does Luck Be a Landlord. And I came across this one because it shares a composer with Star Rift Saga. So I actually got to work with Dan to put the soundtracks of our games in a bundle together. So that was kind of fun to do, and kind of a neat little way of promoting the soundtrack. And another one that's from an indie studio that I've been enjoying a lot is called Supervive. I just would describe it as it's a bunch of League of Legends developers got together and made a battle royale, but that sounds awful on paper if you don't like either of those things. It's so much better than the sum of its parts, and I want to see that studio do well because they're making something really cool. It's just a fun game.
And look, okay, I understand. Yes, it's, let's say, technically cheating, but you know what? Screw it, Jacob. Give the people the pitch of of your game.
Well, Star Rift Saga, it's an action platformer slash it's a Metroidvania that I worked on for a lot of years and kind of just evolved into something that became a finished product. And I got to work with other great people on it. And a lot of its design comes from aspects of other games I just didn't really like the way they did certain things, and I got to do them differently. So it has a lot of RPG like elements. It's got a very cool customization system where you can customize your skills through a Tetris like grid. And you explore a planet and close some rifts and save the galaxy.
Beautiful. Beautiful. I love it. And like I said, everything will be in the links and descriptions below. So please go check it out. Check out the other games as well. But of course, Star Rift Saga is that should be your first click. But your second click should also be heading over to Argo Law. So Jacob, where can the people find you if they want to connect with you, if they have questions themselves, if they're maybe looking to hire you to help out on their legal endeavors?
So my website is argolawyer.com, and I write blog posts there where I talk about some of these things, as well as I do offer free consultations to just kind of talk about what's going on, what you need, what questions you may have, and see if, hey, there's actually something that I can do for you. And yeah, that is argolawyer.com, which I'm sure will also be in the episode description.
Amazing. Jacob, thank you so much again for just your time, your knowledge, your expertise on this matter. I know we've only scratched the very small surface of what this is, but for our listeners, please, if you've enjoyed this podcast, not only A, get in touch with Jacob, but B, let us know, because I know there's many other topics that we've already discussed. If you guys want to hear stuff all about AI and where does that fall under this whole realm, again, I would be love to have you back on the show and continue
Yeah.
talking law with you.
Yeah, thanks for having me. I mean, AI is a big topic. When you sent me, I'd like to talk about these things. I saw AI on there. I was like, that's a really big topic that could be its own thing. And I've given a discussion on that recently. So thanks for having me.
Absolutely. Thank you again, Jacob. And for all of our listeners, I hope you have a great rest of your day, and we'll see you on the next one. Bye now. That was the one. All right, I'm calling it there. That was the one. Thank you, Bernie.